Your landlord just posted a notice on your door saying you have 3 days to prove your immigration status or face eviction. Thousands of Florida families are getting these notices right now, and most have no idea if this is even legal. New state laws are creating confusion about what landlords can and cannot require from tenants regarding immigration documentation. If you're an immigrant renting in Florida, employ immigrants, or own rental property, you need to understand exactly what the law says before you make a move that could cost you your home or land you in legal trouble. Here's what's really happening. Number 1. Senate Bill 1718 transportation provisions create landlord confusion and fear. Florida's Senate Bill 1718, which passed in 2023, includes provisions that many people misunderstand regarding housing and immigration. The law does not actually make it illegal for landlords to rent to undocumented immigrants. Let me repeat that clearly because this is where most of the confusion starts. Florida law does not prohibit landlords from renting apartments or houses to people based on their immigration status. What the law does address is transportation under Section 787.06 of Florida statutes as amended by SB 1718. It became a third-degree felony to knowingly transport someone into Florida who entered the United States illegally and has not been inspected by federal immigration authorities. This provision targets human smuggling operations, not typical landlord-tenant relationships. The penalties are serious, including up to 5 years in prison for violating this provision. However, some landlords and property management companies interpreted this law broadly and started demanding immigration documentation from all tenants. They feared that helping undocumented immigrants move into rental units could somehow be considered illegal transportation under the new law. This interpretation stretches far beyond what the statute actually says, but it created panic among landlords who worried about criminal liability. The practical result has been landlords sending notices to current tenants demanding proof of legal presence in the United States, threatening eviction if tenants don't comply. These demands have no basis in Florida landlord-tenant law. Florida Statute 8343 through 83.68 free governs residential tenancies, and nowhere in these statutes is there a requirement for tenants to prove immigration status to maintain their housing. Number 2, federal fair housing law prohibits national origin discrimination in most cases. The Federal Fair Housing Act under 42 U.S.C. Section 36004 prohibits discrimination in housing based on race, color, national origin, religion, sex, familial status, and disability. National origin discrimination includes treating people differently because of their birthplace, ancestry, culture, or linguistic characteristics common to a specific ethnic group. When landlords demand immigration documents only from tenants who appear foreign or have accents, this can constitute illegal national origin discrimination. The Department of Housing and Urban Development has issued guidance stating that while immigration status itself is not a protected class under the Fair Housing Act, policies that discriminate based on immigration status often have a discriminatory effect on people of certain national origins. For example, if a landlord requires immigration documents from all applicants who speak Spanish or appear Latino, but doesn't require the same documents from applicants who appear to be white or native English speakers, that's national origin discrimination. Landlords do have the legal right to verify that prospective tenants can pay rent. They can check employment, income, credit history, and rental history. These are legitimate business reasons for screening tenants. However, demanding specific immigration documents goes beyond normal tenant screening and enters territory that can violate fair housing laws. If you receive a notice from your landlord demanding immigration papers and you believe it's discriminatory, you have options. You can file a complaint with HUD online or by calling their hotline. You can also contact legal aid organizations in Florida that specialize in fair housing cases. Florida has several organizations, including Florida Legal Services and the American Civil Liberties Union of Florida, that provide assistance with housing discrimination cases. Number 3, Florida landlord-tenant law does not authorize immigration status evictions. Florida Statute 83.56 lists the specific grounds under which landlords can terminate tenancies and pursue evictions. These include non-payment of rent, violation of lease terms, property damage, illegal activity on the premises, and end of the lease term. Failure to provide immigration documentation is not listed as a valid reason for eviction under Florida law. When landlords send notices demanding immigration papers and threatening eviction, they're making threats they cannot legally enforce through Florida courts. If a landlord files an eviction lawsuit claiming the tenant failed to provide immigration status verification, that's not a recognized legal basis for eviction. A tenant can raise this as a defense, and judges should dismiss such cases because there's no legal foundation for the eviction. However, landlords can sometimes accomplish the same result through other means. If your lease is month to month, your landlord can terminate your tenant with 15 days written notice under Florida Statute 8357, and they don't have to give you a reason. If your annual lease is expiring, the landlord can choose not to renew it again without providing a reason in most cases. This allows landlords to effectively remove tenants based on immigration status without stating that as the reason, making it much harder to prove discrimination. Some leases include clauses requiring tenants to comply with all federal, state, and local laws. Landlords might argue that if a tenant is in the country illegally, they're violating federal immigration law and therefore violating the lease. This argument has not been widely tested in Florida courts, and it's questionable whether landlords can use federal immigration law violations as grounds for state eviction proceedings when Florida's landlord-tenant statute doesn't include this as an eviction basis. Number 4, the 3-day notice scam and invalid eviction threats. Many tenants are receiving what appear to be official 3-day notices demanding immigration documentation. These notices often use legal-sounding language and formatting that makes them look legitimate. Understanding what a legally valid 3-day notice actually requires under Florida law helps you identify invalid threats. Florida Statute 83.56 specifies 2 types of 3-day notices. The first is a 3-day notice for non-payment of rent, which must state the exact amount of rent owed and give you 3 business days to pay or vacate. The second is a 3-day notice to cure a lease violation, which must describe the specific lease provision you violated and give you 3 days to fix the problem or face eviction. A notice demanding immigration documentation doesn't fit either category. If you're current on your rent, a notice claiming non-payment is false. If the notice claims you violated your lease by not providing immigration papers, that's only valid if your lease actually contains a provision requiring you to provide such documentation, which most standard leases do not include. Even if your lease does contain unusual provisions about immigration status or legal presence, courts may find such provisions unenforceable as contrary to public policy or fair housing law. Lease provisions cannot require tenants to waive their legal rights or comply with requirements that violate federal or state anti-discrimination laws. If you receive one of these notices, don't ignore it completely, but don't panic either. Read it carefully to see what it actually says. Check your lease to see if there's any provision it's claiming you violated. Document everything by taking photos of the notice and any other correspondence from your landlord. Respond in writing stating that you dispute the notice and consider it invalid if it doesn't comply with Florida eviction law. Number 5, retaliatory eviction protections under Florida Statute 8364. Florida law prohibits landlords from retaliating against tenants who exercise their legal rights. Under Florida Statute 83.64, a landlord cannot discriminatorily increase rent, decrease services, threaten to bring eviction proceedings, or terminate a tenant because you complained to a government agency about code violations, organized or joined a tenant organization, or complained to the landlord about violations affecting health and safety. If you report your landlord to code enforcement for habitability problems, file a fair housing complaint, or contact legal aid about your landlord's immigration document demands, and your landlord responds by trying to evict you, that could be retaliatory eviction. The timing matters significantly. If the landlord's adverse action occurs within 90 days after your protected activity, Florida law presumes the action was retaliatory, and the burden shifts to the landlord to prove they had legitimate non-retaliatory reasons. Retaliation protection doesn't prevent all evictions. If you genuinely stop paying rent or violate your lease in ways unrelated to your protected activity, the landlord can still evict you for those valid reasons. The protection prevents landlords from using eviction as punishment for tenants asserting their legal rights. In the current situation where landlords are demanding immigration papers, if you refuse to provide them or file a discrimination complaint and the landlord then tries to evict you, you should raise retaliation as a defense. Document the timeline clearly showing that you exercised your rights and the landlord's eviction attempt followed shortly after. Number 6. What actually happens in Florida eviction court? Understanding the eviction process helps you protect your rights if your landlord files an eviction lawsuit against you. The process starts when the landlord delivers proper notice as required by Florida Statute 8356. After the notice period expires and you haven't complied or moved out, the landlord can file a complaint for eviction with the county court. You'll receive a summons that gives you 5 business days to file a written answer with the court. This 5-day deadline is strict and critical. If you miss it, the landlord wins by default, and you'll receive an eviction judgment without ever getting to tell your side of the story. Many tenants lose evictions simply because they don't file an answer within the 5-day window. Your written answer must respond to each allegation in the landlord's complaint. You can admit allegations that are true, deny allegations that are false, and state that you don't have enough information to admit or deny certain allegations. Most importantly, you must include any defenses you have, such as the landlord didn't provide proper notice, the eviction is retaliatory, the stated reason for eviction is not legally valid, or the landlord is violating fair housing law. After you file your answer, the court schedules a hearing where both sides present evidence and testimony. You can bring witnesses, documents, photographs, and other evidence supporting your case. The judge will hear both sides and make a decision. If the judge rules in your favor, you keep your housing. If the judge rules for the landlord, you'll have a specific deadline to move out, typically 24 hours after the sheriff posts a writ of possession on your door. Having legal representation significantly improves your chances in eviction court. Many legal aid organizations in Florida provide free representation to low-income tenants facing eviction. Contact organizations like Community Legal Services, Three Rivers Legal Services, or your county's legal aid office immediately when you receive an eviction summons. Number 7. Employment verification requirements create housing instability. Senate Bill 1718's employment verification requirements have indirect effects on housing stability for immigrant families. The law requires private employers with 25 or more employees to use the E-Verify system to check work authorization for new hires. This has made it harder for undocumented immigrants to find legal employment with larger companies. When people lose jobs or can't find work because of E-Verify requirements, they can't pay rent. This leads to legitimate evictions for non-payment that have nothing to do with immigration status directly, but everything to do with the employment restrictions created by immigration enforcement laws. The connection between employment authorization and housing stability is direct and devastating for affected families. Some undocumented immigrants have shifted to working for smaller employers with fewer than 25 employees who aren't required to use E-Verify. Or they've moved into cash-based work in construction, landscaping, restaurant kitchens, and cleaning services. These jobs often pay less and offer no stability, making it harder to afford rent in Florida's increasingly expensive housing market. Landlords who verify employment and income as part of their tenant screening process may reject applicants who can't provide standard employment documentation like pay stubs or employer verification letters. This is generally legal tenant screening based on ability to pay, not discrimination based on national origin, though the practical effect disproportionately impacts immigrants. Number 8. Mixed status families face unique eviction vulnerabilities. Many Florida households include both family members with legal immigration status and family members without it. These mixed status families face particular challenges when landlords demand immigration documentation from all household members. A family might include United States citizen children, a parent with legal permanent resident status, and another parent who is undocumented. When landlords demand papers from everyone on the lease or everyone living in a unit, mixed status families must decide whether to provide documentation for some family members while refusing for others, which essentially discloses who lack status. Some families have responded by having only the family members with legal status sign leases. But this creates problems if those leaseholders need to move out or if the landlord discovers additional occupants not listed on the lease. Many leases include occupancy limits and require landlords' written permission before additional people can move in. If family members are living in the unit but not listed on the lease because of immigration concerns, the landlord could claim lease violations and pursue eviction on that basis. This puts families in impossible situations where following immigration enforcement demands creates lease violations, and avoiding those demands risks other lease violations. Children in mixed-status families suffer particularly severe consequences from housing instability. Frequent moves due to evictions or fear of eviction disrupt their education, separate them from friends and support networks, and create trauma and stress that affects their development and well-being. United States citizen children have the right to live in this country, but when their parents face housing discrimination or eviction threats based on immigration status, the children's rights provide little practical protection. Number 9. Local ordinances and county-level immigration enforcement variations. While Florida has statewide laws affecting immigrants, enforcement and local ordinances vary significantly across the state's 67 counties and hundreds of municipalities. Some local governments have been more aggressive in immigration enforcement cooperation, while others have taken more protective stances toward immigrant residents despite state law limitations. Florida Statute 908-205 prohibits sanctuary policies by state and local governments requiring cooperation with federal immigration enforcement. However, the practical implementation varies. Some sheriff's offices have active agreements with Immigration and Customs Enforcement through the 287G program, which deputizes local officers to perform immigration enforcement functions. Counties with these agreements include Collier County, Bay County, and Pasco County, among others. In jurisdictions with active ICE cooperation, encounters with local law enforcement for any reason, including landlord-tenant disputes, domestic incidents, or traffic violations, can lead to immigration consequences. Some tenants have called police to report landlord harassment or illegal eviction attempts, only to find themselves questioned about immigration status or detained by ICE because local police notified immigration authorities. Other Florida jurisdictions limit their cooperation with ICE to what's legally required without going beyond those requirements. They don't proactively seek out immigration information, don't honor ICE detainer requests that aren't supported by probable cause warrants, and don't participate in 287G agreements. Knowing your local jurisdiction's policies helps you assess risks when deciding whether to assert your legal rights or seek help from authorities. Number 10. Practical steps tenants can take to protect themselves. Given the current situation in Florida, immigrant tenants need to take specific actions to protect their housing and their rights. Start by understanding your lease completely. Read every provision carefully, and if there's anything you don't understand, get help from someone who can explain it. Know when your lease ends, what your monthly rent is, when it's due, and what the lease says about renewals and terminations. Pay your rent on time every time. Keep proof of payment for every rent payment you make. If you pay cash, get a written receipt with the date, amount, and landlord signature. If you pay by check or money order, keep copies. If you use electronic payment, keep confirmation emails and bank statements. Never give your landlord any reason to claim you didn't pay rent or paid late. Document everything in writing. If your landlord makes demands for immigration papers, respond in writing stating that you dispute the demand and consider it potentially discriminatory. Send your response via certified mail so you have proof the landlord received it. Keep copies of all correspondence with your landlord, including emails, text messages, letters, and notices. Know your rights under Florida landlord-tenant law and fair housing law. You can find information through legal aid websites, tenant rights organizations, and immigrant advocacy groups. Organizations like the Florida Immigrant Coalition, Americans for Immigrant Justice, and the Florida Alliance for Consumer Protection provide resources and assistance. Build a support network. Connect with other tenants in your building or neighborhood. Join tenant organizations if they exist in your area. Having witnesses and allies who can support you if disputes arise with your landlord provides both practical help and emotional support during stressful situations. Consider consulting with an attorney before problems escalate. Many attorneys offer free initial consultations, and legal aid organizations provide free services to low-income individuals. Getting legal advice early before you're facing an eviction lawsuit gives you more options and better chances of protecting your housing. If you receive any notice from your landlord that threatens eviction or demands immigration documentation, contact an attorney immediately. Florida's immigration enforcement laws are creating housing chaos for thousands of families. But you have more rights than you might realize. Landlords cannot evict you simply for refusing to provide immigration papers. And discrimination based on national origin violates federal law. If you're facing eviction threats or housing discrimination, don't handle it alone. Like this video and subscribe for updates on Florida housing law and immigrant rights. Comment below with questions or share your experiences. Share this video with anyone who needs this information because knowledge protects families and homes. Contact legal aid immediately if you receive eviction notices or discrimination threats. Your housing rights matter regardless of immigration status, and organizations exist to help you fight back. Stay informed and stay protected.